what we're doing here in the courtroom. So all of our cases are being broadcast live on our YouTube channel. Actually, that's wrong. Live on Magistrate Fink's YouTube channel. And when we're done here today, everything's going to come off of that YouTube channel. It may end up on someone else's channel, but it'll come off of her channel. Okay?
Okay.
All right. Sir, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority for them to make investigation as to representation. Because you've been charged with a felony, you have the right to a probable cause conference within 14 days of today and a preliminary examination within 21 days. And you also have the right to a trial. Do you understand your rights as I've explained them to you?
Yes.
Very good. Thank you, sir. With that, we will proceed with appearances by counsel. We will start with the people.
Good afternoon, Your Honor. Amy Reiser on behalf of the people.
Good afternoon.
And Your Honor, good afternoon. Joe Simon. I appear for arraignment only today, but I expect that I will be filing an appearance after speaking with my client's parents, and he and I have not yet met. So
just for sort of housekeeping purposes, I will put in the paperwork that the request for today for a public defender is denied because you are appearing, and I'll put in for arraignment purposes only.
thank you.
And then I'm going to sign that we're referring him to the local appointing authority because I can't leave him without counsel.
And probably by that time, Your Honor, that will all become moot, but thank you very
Sure.
much.
Okay. Okay, very good. So Mr. Simon, we come to that all important time. Would you like me to read the complaint or do you waive formal reading?
We will waive the reading, Your Honor, and stand mute to all charges.
Very good. Mr. Chatterjee, I'm not going to go through the details of the complaint with you. There are 5 counts. I'm not going to go through them because you've had a chance to speak to Mr. Simon regarding those charges. You will certainly have more time to do so as your case proceeds. You'll be standing mute today and we will enter a plea of not guilty on your behalf. I will schedule you for your next court date. That's going to be a probable cause conference. That will be with Judge Simpson. The next available date he will have will be April 27th at 9 a.m. or as soon thereafter as your case can be called. And that will be by Zoom through the 14A1 District Court. We will send you a notice to appear. And I'm sure you'll have more contact with your attorney regarding that. Do you understand?
Yes.
Very good. Then the last thing we'll need to address in this case will be bond. And there are 2 parts to bond. Bond conditions, those are things the court tells you you can and cannot do. If you violate a bond condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own personal recognizance. And before I make any decisions regarding that, I did hear testimony from the Ann Arbor Police Department regarding what allegedly took place on the day in question. I do have a written request from law enforcement and the prosecutor. I have a check on your criminal history. I have a risk assessment done by our Community Corrections Department. And I'm going to hear from your counsel as well as the people. And then I'll make my decision. Ms. Reiser, would the people like to be heard?
Yes, Your Honor, this case was brought in on an in-custody basis, and I don't know how much information you heard from the swear-to regarding the threats that were in the text messages that the defendant has been sending to the victim, but very derogatory text messages threatening to beat her, threatening to kill her, calling her a slut, a whore, a cunt, and I'm happy to read those into the record if the court would like to hear those, but there are 2 concerns for the victim's safety that the people have in this case. And the first is seems to be a very abusive domestic relationship that the victim literally finally left on this date to flee to her sister's home. Prior to fleeing the defendant's residence and going to her sister's home, she was forced on 3 occasions to perform on the defendant, and if she did not, she was beat with a belt. So she does have bruising on her body. She did report other instances of domestic violence throughout the relationship, but some of the messages that were just sent when she left the residence and the defendant demanding that she return to his residence involve You dumb bitch, get here now or the rest of your life will be the worst hell imaginable. If you're not back, you're failing your class too. And I don't know that the police had the time to investigate it, or I didn't have time to further look into it this morning before authorizing these charges, but it did appear, and I didn't charge, but as if he was going to extort her somehow through her U of M classes. He continues by saying, shut up, bitch. After she said, I need you to promise that you won't hurt me. He says, shut up, bitch. In any way, can you do that? She's pleading with him not to hurt her if she returns. And he says now, wanting her to return to the residence. Because of your behavior, he says, I will only treat you like a pathetic, worthless whore for the rest of the night. If you're good, I'll let you study tomorrow. And I could go on and on. There are more. He said, the second you're in my room, you will get naked and you will kneel. So I think he is not only a danger to the community, but in particular to this victim, because she has finally ended the relationship. So we're asking, per the court rule, because he's charged with a CSC first degree, and there is a high likelihood of conviction, we would ask that the bond be denied.
Thank you, Ms. Reiser.
Mhm.
All right. Sorry, just 1 second. Okay, there we go. All right, Mr. Simon.
Your Honor, can I ask a clarifying question? Ms. Reiser referenced text messages. She read some of them into the record. She specifically referenced the text message of a threat to kill, which is obviously pretty important, but I didn't hear that. And I wonder if that can be clarified, especially as to date.
Yes, hold on. So there are several text messages within. These are the text messages, I believe, that he was sending her to come back to the residence the morning after the assault. But there are multiple text messages, and many of them have threats to kill. Give me 1 minute. This is the test message specific reference. I'm sorry, let me just clarify this. This is reference where I believe there's blackmailing. I don't have a date on it, so they have to did a download because they've just done screenshots from her phone that these are from the defendant. These are from the defendant to the victim. So what does a slave do when given an order, especially when the slave is worth less than the specks of dust below anyone's shoes? Stop thinking you are anything. Get to my apartment right now. You're pissing me off beyond belief. I even know your password. I can schedule, send your professors whatever I want, and it would look like it came from Monday morning, and your family too. And the victim says, are you blackmailing me right now? And he says, you can try me. I guess you have the power right now. Don't think you're anything, bitch. Don't talk to me that way. And she said, no, I'm genuinely asking. It wasn't any sort of tone. I'm just asking. And he replies, you don't give me commands, useless slut. And she said, I was just asking you. He said, I'm going to finish this picture. Get on your knees and wait for me. And she said, where? And he said, wherever you are, and you will ask permission for every 5 breaths you take until I see you next. And the victim's response is, you don't even like me anymore. You don't have to kneel, but I mean the breathing one. No one cares what a useless, pathetic slut thinks. Let me find the death threats. Give me 1 minute. He says, shut up, cunt, I mean it. If I don't get complete obedience from my property tonight, you won't have the ability to think anymore. And the victim responds, you know I'm right. And if you actually wanted to be with me, you wouldn't treat me the way that you do. And he says, I have your location. And she says, I know. Defendant responds, you can turn it off, but if you don't, if you do, I'll still find you, kill you for turning it off. You will obey me tonight. And she said, I know. And he said, it will be sooner or later. And he said, but your life will be worse if it's later. And she says she wants to just break up. He said, the victim responds, I think we should just break up. You don't want to be with me and don't like me. And the defendant's response is, either I choose to break up or I kill you. You've known this. And she says, please just let us both move on before it's years later and we're still unhappy. And he said, you don't have a say. And he's demanding she come back here now. He says, I just am staying because my worthless piece of property needs to be beaten for how it has been acting. You will be back here now. And she's responding, this is not sustainable relationship. I'm not your property.
Mr. Simon?
Yes, thank you. I think that clarifies I think it's gone beyond what I asked for, but that's fine. Your Honor, I can tell you this, as the court knows, as I indicated, I did not have that chance to meet with my client. I do have some of his background that's relevant. I understand he's a student in good standing at the University of Michigan. He's 20 years old with no prior criminal history. I think there are ways to assure the safety of the complainant other than denying my client bond. My understanding is the South Main Street apartment address is his address, and that the complainant has a separate residence and the ability to be away from that address. I understand that she sometimes resided there, but just by to further the relationship. My client is a permanent resident of the state of California, but he is a resident here now, and I understand his plans were to stay in the state of Michigan for the summer. His parents are going to be involved in this representation, and a bond, I think, should be ordered. The one thing Ms. Reiser said was that the conviction has a high degree of certainty. The three principal charges of criminal sexual conduct in the first degree, the aggravating variable, as I understood it from the swear-to, were weapon. And as I understand that was the use of a belt. Again, I've not seen discovery, and we certainly shouldn't try a case at arraignment. But I'm not so sure that there's a certainty of conviction on the capital charges, and especially from the swear-to I heard, especially since the court rule that Ms. Reiser refers to really only applies to capital charges. I'm asking the court to set a $100,000 10% bond. The court can also employ whatever condition that the court needs to ensure the safety of the complainant, such as a GPS tether.
Ms. Reiser?
Are you done, Mr. Simon?
Yes.
There was a point that I stopped in the text messages when he's saying, I just need to beat you for everything you did tonight. Get back here now, 1 minute. And the victim is saying in this text message, it's not even salvageable at this point. I feel like I had a few days where I thought it was, but it's clear it's not. And the defendant responds, I'm getting close to finishing, at which point I will kill you. And she said, just go to sleep. And the defendant responds, your roommates will probably do something, but not before you're dead. So I just have serious concerns for her safety.
Would I be able to say something? Okay.
So here's how this works. You have the right to remain, as I told you, you have the right to remain silent. Anything you say can and will be used against you. It's unfortunate that we didn't have a mechanism to have you talk to Mr. Simon before.
Yeah.
But what I want you, and I'm going to defer to Mr. Simon. If he's okay with you talking, then you can talk. He's shaking his head no. But we're not deciding, as Mr. Simon said, we're not deciding today whether you're guilty or innocent. That's not
Yeah,
the purpose
I
of
understand.
today. The purpose of today is to advise you of your rights, ensure that you get an attorney, get you the next available court date. And then it's my responsibility to set bond conditions and a bond amount to ensure the safety, not just of the person identified as the victim, but as of the community at large. And then to ensure that you're going to come back to court.
Yeah, no, I understand. My plan was just that, I guess because I haven't spoken with Mr. Simon, I guess there's like other information, but I won't speak if he doesn't.
Yes, Mr. Chatterjee, we'll have time to go over those things, I assure you. And no one here is going to determine the intent of your those messages. I have a strong feeling what you want to tell me, but we're not going to do that today, okay?
Okay.
Okay, Ms. Reiser, were you done? Mr. Simon, were you guys done?
Yes.
Yes, Your Honor. Well, I just want to add one thing if I can.
Yeah.
I understand Ms. Reiser's concerns. They're pretty obviously derived from the things she read, but I would also repeat that there are ways to protect the safety of a complaining witness versus straight incarceration and denial of bond, such as a posting of a serious bond, such as a GPS tether, and confining his movement and ensuring no contact with her.
Thank you. All right, a question, Mr. Simon, you're not going to know the answer, but your client is. So I'm going to ask a really specific question, and I'm just looking for a really specific answer. You are attending the University of Michigan, is that correct?
Yes.
What program are you in?
I'm in the College of Engineering computer science major.
Okay, and do you have any classes with this other individual?
No.
Okay, do you know what
No.
program she's in?
She's LSA psychology.
Okay. All
So
right.
not in the same college.
Okay, I'm, again,
Mhm.
I got it. I'm a grad. I went there. I know how college works. I even know how law school works. I got it. I try to ask really specific questions because I don't want you to say something that's going to be used against you, even the littlest thing.
Okay, thank
Okay.
you. Yes.
All right, so that's for your protection, and that's why Mr. Simon doesn't want you talking either, because the smallest thing could create a large problem for you. I am going to set bond conditions for you. These bond conditions are not in the order of importance. They're just in the order listed on the form I'm going to read from. If you remain in custody, some of these things will not kick in immediately, but your bond conditions, they will remain in full force and effect until changed by the court. As I've already told you, if there's any change to your contact information, you're required to notify the court. When and if you are released, you will be required to have a GPS tether placed on you. That's going to be location tracking only.
Okay.
That's going to be so we know where you are at all times.
Okay.
That tether would have to be placed prior to your release.
Okay.
Appreciate that they don't do tethers on the weekends.
Okay.
So you can tuck that away for a minute.
Yeah.
And when I require a tether, I don't let people leave and come back to get the tether because that defeats the purpose of the tether.
Okay.
Okay. You are not to use, purchase, or possess alcohol, recreational marijuana, or illegal drugs. And I'm going to have you do standard supervision for drug and alcohol testing. That would start upon your release. Do you understand?
Yes.
And that's out here at Community Corrections in the same complex where you and I are currently located. We will get you their address. Failure to appear may result in a warrant for your arrest.
Okay.
Next, you are not to leave the state of Michigan without prior permission of the court. So if it's your intention to go back to California at some point, you would have to discuss that with your attorney. Your attorney would discuss that with the court. We would determine whether to give you permission to do so. Okay.
Yes.
You're not to purchase or possess any firearms, ammunition, or dangerous weapons. Do you understand?
Yes.
How many firearms do you own?
0.
Are there any firearms in the address where you're currently staying?
No.
Thank you. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. Do you understand?
Yes.
Thank you. You are to have no contact with Kyle Lesmer I may be pronouncing that last name wrong. You are to have no contact with her. You are to have no contact with any of her immediate family members. And I don't want you having contact with any of her roommates.
Okay,
When I say no contact, no direct or indirect contact with the above named individuals in person or through others. No telephone, email, texting, instant messaging, Snapchat, Slack, whatever the cool kids are doing, you're not doing it. No contact means no contact. Do you understand?
yes,
And you can't have other people be in touch with her or any of those other people on your behalf. Do you understand?
yes,
All right. You are not to go to the home, work, school, or any house of worship that Ms. Leismer attends, whether she's there or not. Now, to be more specific, since you're both at the same university, I don't want you, there's no reason for you to be in her classes. You're taking classes in completely different departments.
yes.
You don't have any classes together, right?
No, I do not.
Okay, so if you're at, I was gonna say the CCRB, but I think they just tore it down. If you're in the ugly studying
Yes.
and you get up to go to the restroom and you see she's there, you're gonna
Yeah.
leave.
Okay,
If you're walking into Kroger to go grocery shopping and she's there, you're not.
okay,
If you, well, you're not supposed to be drinking any alcohol, but you're picking up your friends from the bar to drive them home safely and she's there, you're out.
okay,
And there will be no, I didn't understand with these provisions. You have
Yeah.
been explained quite thoroughly. We've explained this to you in each condition. I've asked if you understand, and each one you've said yes.
yes, I understand.
Okay. You're not to violate any criminal law. You're required to appear at any and all court hearings and other places as directed by the court. Obviously, drug testing, you have to physically go in. Your next court appearance will be by Zoom. Those court appearances may change to be in person. In that circumstance, the court will let you and your attorney know. Again, all of your conditions, they exist whether you're in custody or out of custody. Do you understand your conditions? I haven't told you your bond amount yet.
Yes, I understand.
Any clarification or questions, Mr. Simon or Ms. Reiser, on the conditions?
No, Your Honor.
No, Your Honor.
All right. I am not going to keep you without a bond.
Okay,
I think I can under the
Oh.
court rules. I think I certainly could do that, but I am not going to do that. I am hoping that understanding your bond conditions and understanding the gravity of these circumstances, that you will follow your bond conditions
yes,
once I give you a rather large cash bond. It is not my intention with this large cash bond to keep you in custody, but it is my intention to make you appreciate the severity of these circumstances. So based upon the information that's been presented to me, my concern for the safety of the victim, my concern for an ongoing pattern of behavior of a very concerning nature, especially when someone is trying to get out of, I use the term relationship loosely, I guess, get out of a circumstance and can't seem to do so. I believe a large cash bond is appropriate along with the GPS tether. If we had tethers that I could put on both of you, so I knew that you were nowhere near her, I would, but that would be unfair to her, and that technology doesn't really exist. That's really the only way to ensure that you stay away from her or to
Okay.
keep you in custody. I'm going to set a large cash bond. I believe that $250,000 cash or surety, no 10% privilege is appropriate. Again, it's not my intention to keep you, but it certainly is my intention to have you understand the severity of this. Certainly if that's something that your family can't post, they can get in touch with some bail bonds people or something along those lines. So, Mr. Chatterjee, we've done a lot of things here today. Do you have any questions regarding what's happened today?
Could I just get some clarification on how the GPS tether works? Or like-
Mr. Chatterjee, I will be following up with you.
Okay, yes, of course.
And when you get the tether, they don't just slap it on you. They're going to be very specific with how that tether works.
Okay,
Okay, and they'll go over all the rules. You'll have to pay us a deposit of $25 and they will explain all the requirements on that.
okay.
All right, anything further for the people?
No, Your Honor, thank you.
And Mr. Simon, anything further?
Nothing further on the record for this matter, except to thank Your Honor and staff for assisting me very greatly this morning. And since she'll be going away for a little while, I suppose I should acknowledge formally to Ms. Reiser that I've been driving her crazy a little bit lately, and I appreciate her letting me do that more this morning very much.
Appreciate that. Thank you. Yeah.
All right, so then, Mr. Simon, we are all set. Thank you so much.
Thanks.
Mr. Chatterjee, you are going to stand up and go to the door, and that'll let